everyone. Welcome to Crime in Court. This is the 1996 Menendez brothers trial, California versus Eric and Lyle Menendez, on trial for the homicides of Kitty and Jose Menendez, their parents. And we are on the defense's case, part 15. We are going to continue where we left off, which is in the middle of Deputy Dwight Van Horn's testimony. He is a crime scene investigator for the or not crime scene. I'm sorry. He's a firearms examiner. Sorry. He's a firearms examiner for the LA County crime lab. That's why I said crime scene investigator. Sorry. So he's been talking. He's already testified on direct, right? Are we moving on? I think we're moving on to cross. I don't recall. Oh, direct continued? Maybe. Oh, I think we finished. Sorry, I was looking at my notes. I think we just finished direct. So I think we're about to move on to cross. Well, let's find out. All right. Instead of me thinking about it, let's just do it. So let's get started. Here is part 15, Menendez Brothers trial. We're coming back from the afternoon break on Wednesday, November 29th, 1995. Or lunch break, I should say, not afternoon break. So we're coming back from lunch. The court says, "Are we ready to proceed?" "Yes," Mr. Khan says. The court says, "Let's get the jury out, please." The jury entered the courtroom and the following was held. The court says, "Okay, the jury is back and the witness is on the stand. Now we'll have cross-examination." So yes, we just completed direct. We're now moving on to cross. Mr. Khan, for the state, will be doing the questioning. And he says, "Deputy, I'd like to direct your attention to this exhibit that has been placed on the board for your testimony, and that is Exhibit 324, which depicts a shotgun being fired and a cloud in front of that shotgun." Remember, we looked at that in the last stream. Let me pull it up for you real quick here. Okay. I pulled up the exhibit on the screen. This is what they're talking about. You can see the barrel here of a shotgun and a poof of, he called it gases, and then more from the powder of the gunpowder and other gases coming out of the barrel of the gun. Whoops. So that was the exhibit that they're about to refer to. We talked about it. They talked about it on direct in the last episode. So, Mr. Khan says, sorry, let's start over. "So, Deputy, I'd like to direct your attention to this exhibit that has been placed on the board for your testimony, and that is Exhibit 324, which depicts a shotgun being fired and a cloud in front of that shotgun. Can you tell us what that cloud represents?" "Yes, sir. That's the product of combustion from the gunpowder burning inside the shot shell and then exiting the barrel of the shotgun." "And does that mean that when you fire a shotgun using the type of ammunition in this case, that it creates a big white cloud that fills up a room?" "That fills up the room?" "Yes." "No." "Okay. When you say the products of combustion, are you saying that that is a smoke, a white smoke?" "No. White gunpowder, that's used in modern cartridges. It's what's referred to as smokeless powder. It produces a minimum of smoke. There's that picture has been the picture has been lighted in such a way that it would show to a better view than you could see with the human eye the products of combustion that exit outside, or excuse me, behind the projectiles." So basically, it's enhanced, the lighting is enhanced so that you can see what the human eye cannot in these photos. "So the type of ammunition that was used in this case is a smokeless powder?" "Yes, sir." "And does that mean it leaves no smoke?" "Not absolutely no smoke, but there may be some smoke that's generated by, in the case of buckshot pellets, as the buckshot goes down the barrel and interacts with the other pellets and the barrel itself, It can create somewhat of a lead dust that could also be depicted there. There's also going to be a minimal amount of smoke because, once again, they refer to it as a smokeless powder. Okay, if you were to fire 12 shots, let's say, of this smokeless powder, would it make it difficult to see in the room? Objection, Your Honor, assumes facts, not an evidence. He's referring to Eric Menendez's testimony, who said that he actually told law enforcement that there was smoke in the room when they first observed the parents, which would have been, an hour plus after, an hour and a half after the incident. So there would have been no smoke at the time. So that was something that kind of made them suspicious to the officers. That was something that stood out in Eric's initial interviews. So there's that. Okay. If you were to fire 12 shots, let's say, of the smokeless powder, would it make it difficult to see? And objection, assumes facts, not an evidence. Eric never said it was difficult to see in the room. He just said that he remembers the smoke. I think he even mentioned the smell of it too in his recollection because he was traumatized and he was in shock. So he didn't know, that I'm sure it just was a slip of the tongue because he was remembering things that out of his shock. Anyways, I mean, he didn't mean to say it in front of law enforcement. All right, so overruled. The witness says, I don't believe so. Mr. Khan says you would not expect 12 shots of this type of ammunition to be being fired to create any visibility problems. Ms. Abramson says, I'm going to object, Your Honor, calls for speculation and improper hypothetical this type of ammunition. The court says, sustained as to the form of the question. Okay. Did you make a determination as a result of your review of the material that Fiachi ammunition was used in this case? The components that I could identify is a manufacturer of the wad that's called Gualandi and I'll say Gualandi. I don't know if I'm saying that right. Gualandi primarily loads in Fiachi ammunition, but it's not outside the realm of possibility that those components could be loaded in other shot shells, but best bet is yes, it's Fiachi ammunition. Is it your understanding that Fiachi uses smokeless powder? Yes. Would you expect 12 shots of the smokeless powder to create any visibility problems? I'm still going to object, Your Honor, as insufficient factual foundation. Overruled, but it's clear what you mean, or it's unclear what you mean by visual problems. Mr. Khan says, okay, would you expect that 12 shots of smokeless powder being fired would make it difficult for the shooter to see? Ms. Abramson says, I'm going to object to that also, Your Honor, insufficient factual foundation for the hypothetical. Court says sustained as to the form of the question. Would you expect that the smoke, if any, well, let me ask you this. You said that smokeless powder creates a minimum of smoke. How much smoke would there be after 12 shots are fired? There would be perceptible smoke. I think you could say that there would be smoke in the room. Yes, I think you could say that. That you could perceive with your eye? Yes. Well, that backfired now, didn't it, Mr. Khan? That's not the answer you were hoping for. Would it be such that you would anticipate that it would make it difficult to impair vision in any way? Objection, Your Honor. I think it's. Court says, is there an objection? Ms. Abramson says, was the question difficult to impair vision? Did I hear that right? The court says, let's have the question read back. Ms. Abramson says, vague and improper, hypothetical. The last question was read back as follows. Question, would it be such that you would anticipate that it would make it difficult to impair vision? Difficult to impair vision? That's a weird way of saying it. He says, I'll rephrase it. Would you expect that 12 shots would create smoke such that it would impair vision? Again, I'm going to object as insufficient facts for proper hypothetical. The court says, are you talking in an open area? In a room size of a room, things of that nature? Mr. Khan says, in a normal sized room, Would you expect that the smoke would be such that it would impair vision? Objection, vague. Do you understand the question? Asks the court. The witness says, yes, I do. Court says, okay, you may answer it. The witness says, no. So he does not think that the smoke would impair vision. Now, you indicated that in order for you to make a reliable estimate to the shotgun patterns or spread patterns that would be caused by a particular weapon, you would need the actual weapon. Is that correct? That's correct. Directing your attention once again to the same exhibit, I would like to point out, for example, what appears in the center of this exhibit of 324. There appears to be a spread here, approximately 3 inches in size. Do you feel that based upon your knowledge of shotguns and shotgun spreads that you can look at that and say, for example, that was shot from so many feet away, give or take some variable, without actually having the actual shotgun to experiment with? Not reliably. So, for example, if someone were to testify, I think that this shot was fired from 14 feet away, give or take 4 feet, would you disagree with the reliability of giving such an estimate without having the shotgun to work with? Objection, Your Honor, calls for speculation without a complete hypothetical. Overruled. The witness says, I'm sorry, would you repeat the question? Yes. If someone would testify that he could look at a spread such as that and say, in my opinion, that was shot from 14 feet away, give or take 4 feet, and that person had no contact with that weapon involved, would you agree that that would be a reliable estimate? Would I agree that it is reliable? No. Well, why is that? Well, once again, by looking at the pattern, you really don't know what type of ammunition is used. You don't know the gun involved. This is impeaching or trying to discredit Dr. Fackler, because Dr. Fackler looked at images of spread and said, I estimate that to be whatever, whatever. So they're trying to discredit Dr. Fackler. I knew it, because the next question is, you didn't read Dr. Fackler's testimony in this case. No. Um, sorry, let's go back a question. So he said it wouldn't be reliable. He asks, well, why is that? Well, once again, by looking at the pattern, you really don't know what type of ammunition is used. You don't know the gun involved. You didn't read Dr. Fackler's testimony in this case? No. Good. So you can't ask him about Dr. Fackler coming up with a range or whatever. All right. You're a law enforcement officer? Yes, sir. You've been a law enforcement officer for how long? Since February of 1973. And you've worked for the county of Los Angeles that entire time? No, sir. I've worked for the Sheriff's Department since September of 1981. And where did you work before 81? From 79 to 81, I worked for the Hermosa Beach Police Department, and prior to that, for 7 years, I worked for the Trenton, New Jersey Police Department. And what is your educational background? I have an associate's degree in criminal justice and other college courses, but no degree past an associate's. Okay. Associate's degree is a 2-year degree? Yes, sir. Do you have high school plus 2 years? Yes, sir. You're not a doctor or an engineer? No, sir. And you've testified as an expert witness in the past? Yes, sir. And in the area in which you have testified as an expert witness is as a firearms examiner. Is that correct? That's correct. Is that the only area in which you've ever qualified as an expert? Yes. You've never done a reconstruction of a shooting? Objection misstates his testimony. Court says, well, it's a question. The witness says, Court says, go ahead. Yes, sir. Thank you. I've assisted in attempting to do reconstructions and then doing reconstructions, yes. So, yes. So, you've completed reconstructions of shootings? Yes. What type of shooting did you reconstruct? Regular homicides. If there is such a thing as a regular homicide, deputy and officer involved homicides. And what types of reconstructions? What do you mean by reconstruction? Oh, an attempt to verify through evidence what is reported by witnesses, basically. Well, have you ever looked at the physical evidence from the crime scene alone and, based upon the injuries or the evidence of shots being fired at the scene, sought to determine what happened without the benefit of an eyewitness? Probably. What do you mean by probably? Well, I can't recall any specific incidences, but in occasions where we have been called out to crime scenes where the crime scene is still fresh, you're working with the handling detective in an attempt to answer questions that would help them piece together the crime in that respect. Yes. So, based upon the physical evidence at a crime scene, you feel that you sometimes can form conclusions concerning matters such as the number of shots fired and the trajectories involved. In the raw number of shots fired, that's possible. And yes, trajectories, that's possible too. Okay. Do you feel that in a given case, you might also be able to reach a conclusion concerning sequence of shots fired? I think the probability that would depend on a number of things, the number of shots that were involved and other evidence that might not be available at the crime scene. In other words, relying on the coroner to find out what the shots were to the body, what damage those shots have done. So you don't disagree with the notion that reconstructions can be done. You're just saying that in this case, you didn't do a reconstruction. Is that correct? That's correct. Now, in your capacity as a law enforcement officer, you have been called by the prosecution in the case, or I'm sorry, you've been called by the prosecution in the past. Is that correct? Yes. In fact, would you say that normally you are called by the prosecution rather than defense attorneys? Yes. How often have you been called by a defense attorney in the past? Actually called or actually testified? Testified. I think this is about the fifth time. So I believe you said you qualified about 250 times. Is that correct? In excess of 285. So 285 times. In those 285 times, you've only been called by the defense 5 times. Is that correct? Well, in criminal matters, 5 times. In civil matters, I think probably say maybe 8 to 10 times. And you were called by the prosecution in the first trial. Is that correct? That's correct. Well, why didn't you call him this time? And you normally assist the prosecution in preparing a case. Is that correct? Yes. And you assisted the prosecution in the first case. Correct? That's correct. And you gave the prosecution the benefit of all your assistance, didn't you? That's correct. And you told the prosecution all the conclusions that you could reach concerning this crime scene. Isn't that correct? I believe so. And you didn't hold anything back from the prosecution. You basically gave the prosecution the benefit of all your education and knowledge. Is that correct? That's correct. And you were not able to do a reconstruction. Is that correct? I'm going to object to the form of the question, rephrase the question. Well, the sheriff's department was not able to do a reconstruction of this incident. Is that correct? Same objection, assumes facts not in evidence. They were unable. The court says, well, as phrased, it's argumentative. Okay. Based upon your review of the evidence in this case, were you able to do a reconstruction? Singly by myself? Yes. No. Did you consult with other people in the sheriff's department as to whether or not a reconstruction could be done in this case? No. And to your knowledge, the sheriff's department in this case did not do a reconstruction. Is that correct? That's correct. And then you became aware that the Los Angeles District Attorney's Office was going to be using an outside expert for the purpose of offering a reconstruction. Is that correct? Objection hearsay. Overruled. You can answer the question. The witness says yes. When did you become aware that the Los Angeles District Attorney's Office was going to be using an outside expert for the purpose of presenting a reconstruction? probably September of this year, thereabouts. And since you've become aware that the LA District Attorney's Office was going to be using an outside expert, how much have you consulted with the defense attorneys representing Eric and Lyle? Your Honor, I'm going to object as irrelevant as phrased. Overruled. Wow. Only after I was subpoenaed, and I believe twice. When were those two occasions? One of them was last week, I believe, and I don't recall the first date. I'd say within about a month before that. So you consulted with them just yesterday, didn't you? I reviewed evidence that I had never seen before yesterday. Okay, what I'm asking you is how many meetings have you had with the defense lawyers in this case? As if meeting with a witness is a nefarious thing. He says, I guess counting yesterday could be 3. And was the prosecution invited to the prior meetings? What? No, why do you invite the prosecution? No, you don't need to do that. That makes no sense. Why would the prosecution be invited if the defense is using this person as a witness? Why would the prosecution invite them to this? And Ms. Abramson aptly says, objection irrelevant, Your Honor, and it is sustained, thank goodness. So that's good. Mr. Khan says, was the prosecution present during any of the meetings that you had with the defense lawyers in this case? Objection irrelevant. Overruled. He says no. There's no point. There's no. A defense attorney can meet with their witness and the other side doesn't need to be present. So they're making it seem like it's some kind of nefarious thing, which it isn't. Which I find just to be mind-numbingly exhausting with this prosecution here. Did you know whether the prosecution wanted to be present during the meetings that you had with the defense lawyers in this case? Objection irrelevant. And as it should be, it was sustained. And yeah, you can't, like, who cares if they wanted to be present? That doesn't matter. You had every right to call them. You could have called them, buddy. Like, what is this? We're in bizarro world right now. And Mr. Khan says, Your Honor, I think this goes to bias, if I may inquire. The court says, well, it would call for hearsay, unless you can establish some foundation. Mr. Khan says, did you invite the prosecutors to any of the meetings you had with the defense lawyers in this case? Objection irrelevant, and it's not his responsibility to do so. This is so ridiculous. This line of questioning is bizarre. And of course, the biased judge overrules it. The witness says, they weren't my meetings. Exactly. It wasn't his meeting to invite the prosecutors to. They weren't my meetings. It wasn't up to me to invite anybody to the meetings. Mr. Khan says, did you have conversations with Ms. Nahara in which she indicated to you that she would like? Objection hearsay. I haven't heard the question yet, says the court. Ms. Abramson says, well, it's about to be hearsay, Your Honor. The court says, well, until I hear the question, there might be some exception to the hearsay rule, so I can't rule upon it yet. That's garbage because you can't unring a bell. And if you're asking a question in the form of, it sounds like this happened and it may or may not, and whatever. It's just whatever. He says he can't rule upon it yet. Mr. Khan says, did you have conversations with Deputy District Attorney Nahara or anyone in the District Attorney's office concerning our desire to be present at such meetings? Yes. And did you become aware of our interest in being present at such meetings? Objection, Your Honor. This calls for hearsay. The court says you have to establish a foundation for this. Objection sustained. Mr. Khan says, who did you have such conversations with? I believe both of you. And in those conversations, did either I or Deputy District Attorney Nahara tell you that we wanted to be present during such meetings? Objection, hearsay. Overruled. The witness says, for the first meetings, you said you wanted to be present. And after that, You weren't returning my phone calls. Bam. The witness is like, okay, you want to do this? Let's do it. Did you attempt to contact the district attorney's office to tell us that you were having such meetings? Objection, irrelevant. Overruled. The witness says, I attempted to, after you guys didn't show up for the first meeting and didn't return my phone calls, I figured you were no longer interested in talking to me. Don't ask a question you don't want an answer to. Mr. Khan says, when you asked that we failed to show up, you attended a meeting in which we were supposed to show up. Is that correct? That's correct. And we asked to meet you at a particular place. Is that correct? Your Honor, I'm going to object to this as hearsay and counsel's testifying. Overruled. Is that correct? Mr. Khan says. Yes. And is it your claim that you were present and we were not present? Is that correct? I was waiting for you on the district attorney's office on the 17th floor in the conference room. You guys didn't show up. He's like, I was there. Is that where we asked you to meet on the 17th floor, or did we ask to meet you outside the building? Outside the building. And you didn't wait outside the building, you waited on the 17th floor. Is that correct? Miss Abramson says, Your Honor, this is argumentative and it's all hearsay. Overruled. He says that's correct. Mr. Khan says so you didn't ask at the place, you didn't wait at the place that we asked you to meet. Is that correct? It was represented to me that at the time of the meeting that the criminal courts building would be locked. When I got there, the doors were open. So I went inside the building, went up to the district attorney's office, and immediately paged Ms. Nahara. And she wasn't there, correct? I'm sorry? She wasn't there? No. Do you realize that she would be downstairs waiting as we had asked you to wait? Well, I had no idea where she was. That's why I paged her. Is this like some nefarious thing you're trying, like, what kind of get is this? I don't understand. But you didn't wait at the place that we asked you to, and he says that's correct. And the bottom line is that the Los Angeles Sheriff's Department and including yourself have been meeting with the defense attorneys concerning the testimony in this case without inviting the district attorney's office. Is that correct? Objection, Your Honor, calls for hearsay, matters beyond his personal knowledge as to what the department is doing. Objection sustained. Mr. Khan says, the fact of the matter is that you held several meetings with the defense lawyers without inviting the district attorney's office. Is that correct? Objection, argumentative, and misstates the testimony. As phrased, it's argumentative, says the court. Well, how many meetings did you attend without the presence of the district attorney's office? Asked and answered. Overruled, you can answer the question. All 3 meetings. Mr. Khan says, now, as part of the preparation in this case, did counsel for Eric and Lyle Menendez ask you to review some materials? Yes. And what did you review? I reviewed Dr. McCarthy's testimony at the pretrial hearing and Dr. McCarthy's testimony in this trial. Anything else? I have part of Lyle and Eric Menendez's testimony, but I've never read it to any degree. Anything else? The report from Dr. McCarthy, or yeah, Mr. Doctor, whatever. Anything else? I don't believe so. Did you also say that you reviewed the coroner's report? I have that from the original time I looked at this case back in 1993. Okay, so you reviewed how many volumes did the testimony of Dr. McCarthy from the pretrial hearing and from the trial consist of? I don't know. It was more than 1 volume, is that correct? Yes. Would you agree it was about 5 volumes? Probably. And your assignment given to you by the defense lawyers representing Eric and Lyle Menendez was to look for errors in his testimony. Is that correct? Objection, Your Honor. Court says sustained, assumes facts not in evidence. What was your assignment? Objection, Your Honor, assumes facts not in evidence. The court says rephrase the question. What were you asked to do in connection with that material? Review it and testify in court. And not discuss it with the defense counsel prior to your testimony? I'm going to object to that as argumentative. Sustained. Was it your understanding that counsel wanted to discuss it with you before they called you as a witness? Yes. And did you review it and relate to them certain observations that you made in the transcript? Yes. And did you point out what you perceived as errors? Yes. And was that your understanding of why it was given to you so that you can go through that transcript and you can find errors in the testimony of Roger McCarthy? Yes, the same errors I pointed out to her, I tried to point out to you and Miss Nahara also. But that was your assignment, to find errors in the prosecution's case and point it out to the defense counsel. Is that correct? Objection, Your Honor. Argumentative. Overruled. You can answer the question. The witness says, I did not receive an assignment. I received a subpoena. And like I do for all subpoenas, I try to be prepared so I know what I'm talking about when I come to court. In this case, what you did was more than prepare. In this case, what you did was you prepared defense counsel. Is that what you did? Objection, Your Honor. Argumentative. Sustained. Did you prepare defense counsel and point out to defense counsel the questions that should be asked? No. And what did you do with the material? With the errors that you observed in the testimony of Roger McCarthy? I made them aware, made Ms. Abramson aware of them. And you are aware of the fact that she would then use that in court to try to attack the testimony of Roger McCarthy. Is that correct? Objection, Your Honor, calls for speculation and is argumentative, and this is totally improper. Like, this is what experts do. You review a report, testimony, whatever, and you report back what you think was correct, what you think might be, you might have some questions. You report back your findings. You review it, you make conclusions, and you report back. And if that conclusion is this expert is wrong, so be it. And are you aware of the fact that she would then use it in court? Objection, argumentative, overruled, of course. Sorry, I don't know. There's some noise outside, and then the dogs decided to bark. All right. So Mr. Khan says, sorry, it was overruled, of course. The witness says that was my assumption. Yeah. Mr. Khan says, and are you being paid as an expert witness? I'm working for the County of Los Angeles. And you did this during regular work hours? That's correct. Did you discuss with your supervisors the fact that you would be looking for errors in the prosecution's case at the request of criminal defense counsel before you undertook this task? My supervisors were aware that I was preparing for court testimony in response to a lawful subpoena. Stop trying to make it into something it's not, you jerk. And were you aware of the fact that you were looking for errors in the prosecution's case, or were they aware of the fact that you were looking for errors in the prosecution's case to assist in the defense of Eric and Lyle Menendez? Yes. Like, so what? And how many representatives from the sheriff's department are here today in the audience? Three. And who are they? Captain Michael Soderberg, who's in charge of the crime lab, senior assistant lab director, Ronald Linhart, who's the next witness, and Deputy Patricia Finn. And then you reviewed some exhibits that are in evidence to assist counsel as well. Is that correct? What exhibits? What do you mean? Were you asked to remain the other day in court to review some court exhibits and give counsel the benefit of your opinion concerning certain exhibits? I believe the other day when I remained behind, it was to look at the Mossberg shotgun. Did you review any other exhibits? I don't recall. I don't believe so. Now, I believe you said that after reviewing the testimony of Roger McCarthy, you came up with some bones of contention. Is that what you said? Objection, Your Honor, misstates the testimony. Overruled. The witness says, I found what I believe to be errors. Yes. And one of your bones of contention was in regard to size 8.5 birdshot. That was one of the things I pointed out. Dr. McCarthy testified that there is size 8.5 birdshot. Is that correct? I believe he identified the shot in this case as 8.5 birdshot. And is it your contention that there is size 8.5 birdshot, but that just wasn't the birdshot in this case? That's correct. You agree with Dr. McCarthy that you agree that there is size 8.5 birdshot, like it exists. That's correct. And you made a determination as to the size of the shot in this case by looking at the pellets visually or by measuring them, by weighing them. And how many did you weigh? Of the birdshot? Mm-hmm. I don't remember. I believe 10. How much do they weigh? I don't recall. I can tell you approximately what 10 of them would have weighed. I'm not asking for the approximate, I'm asking for the measurement that you made in this case upon which you formed an opinion and testified in court that the size of the bird shot in this case is either 6 or 7.5. I don't recall the specific weight. How much should 10 pellets of 8.5 birdshot weigh? 8.5? Is that what, I'm sorry, you said it was either 6 or 7.5. Is that correct? Right. How much should 10 pellets of size 6 birdshot weigh? The approximate weight of a grain, or excuse me, a pellet of number 6 shot is approximately 2 grains, so it would be about 20 grains. The weight of number 7.5 shot is approximately 1.5 grains. So 10 pellets of number 7.5 would be 15 grains. And how much would 10 pellets of 8.5 weigh? I don't know. Did you seek to obtain size 8.5 for the purpose of weighing them? We don't have any in our exemplar collection, so I didn't compare them to that. They would be smaller than either of the two weights I gave you. You don't recall what the weight was in this case, is that correct? No, I don't. So you can't say how far off Roger McCarthy was, is that correct? Well, I can tell you that based upon looking at many shotgun pellets and weighing these, that it was my opinion that they were either number 6 or 7, 7.5 shot. Aren't birdshot pellets also measured? Not reliably. Now, another bone of contention that you had with Dr. McCarthy was that he used the term overshot wad rather than overpowder wad. Is that correct? Yes. Is that a bone of contention for you? Well, because somebody who takes the stand in a criminal case should be able to tell the difference about basic things like components of a shot shell. Bam. Don't ask if you don't want to know. And what was your understanding that Dr. McCarthy was referring to? A piece, I don't know. I wasn't here for his testimony. I didn't see it. Well, you read his testimony and you found a problem with his testimony. Is that correct? Well, the fact of in 1995 or even 1989 referring to overshot wad, yes. Are you saying that there's no such term as overshot wad? No. What are you saying? I'm saying it's an old term for old ammunition. Modern ammunition is crimped using what they call a star crimp, which negates the need for a wad on top of the shot. Are you saying that all modern ammunition is star crimped? No. You can still purchase ammunition that has the overshot wad, can't you? Not that I'm aware of. What is an overshot wad? It's a wad that goes over the shot, and the old form of crimping shot shells is a roll crimp where it rolls the plastic or paper down, and then the overshot wad presses the components together. What is a star crimp? A star crimp is where the shot shell is folded down into or onto the top of the shot shell, and that retains the components of the shot shell. Your Honor, I have in my hand three shot shells. I'd like to mark this as collectively as 326. The court says it would be 327. Counsel says, care to show it to us? Or, sorry, Ms. Abramson says, counsel, care to show it to us? And he does. The court says, shotgun over there. The witness says, no, sir. Just making sure that he can't freak out and load the gun and start shooting people in the court. So he says, no, no, sir. The bailiff says that the shotgun is over here. So just making sure that, nothing can happen. Mr. Conso, showing you 327. Can you tell us what this is that you're looking at? Yes, three types of ammunition that were not used in this case. And what type of wad does that ammunition have? They have overshot wads. Is that the type of wad that Dr. McCarthy was referring to? Yes. And is it your testimony that that ammunition is no longer purchased or no longer sold? I was referring to the ammunition that was used in this case. When Dr. McCarthy was testifying, wasn't he referring to the fact that some ammunition, not necessarily in this case, but some ammunition is made with overshot wads? I believe that he was identifying a component from the crime scene as an overpowder wad, an overshot wad. And it is your testimony here that that type of ammunition is no longer made. Is that correct? In the ammunition that was used in this case, that's my testimony, yes. I'm not asking you that. I'm asking you, was it your testimony here in court that the type of ammunition that you see in front of you right now is no longer made? No, obviously, this is a current ammunition, but the context of my remarks was in the ammunition that was used in this case. Stop twisting my words. And will you agree that the size 8.5 buck is also commercially available? 8.5 birdshot. 8.5 birdshot? Yes. Would you agree with that? Yes. Your Honor, I have a box of size 8.5 birdshot. Ms. Abramson says, Your Honor, unless there's going to be a foundation as to where all these miraculous items come from, the court says, without that sort of remark from counsel, do you have some specific objection? Ms. Abramson says, yes, I would object unless there's going to be a foundation laid as to where these materials came from. Court says, all right. Well, at this point, it's not being received, it's just being marked and shown to the witness. So, as with other exhibits, that's the way we'll proceed. So it will be marked as 328. Ms. Abramson says, I'm going to object to this, Your Honor. This is a 410 gauge, whatever that is, total, or however you say that, totally irrelevant to this case. And the court says, I haven't heard it yet. So at this point, as I said, the exhibit is being marked and it will remain marked as 328. Mr. Conso, showing you 328, can you tell us what this is? Yes, this is a box of Winchester target ammunition in 410 gauge containing 1.5 ounce of 8.5 shot. Sorry, I'm not a gun person. I don't know any of this stuff. Does 8.5 birdshot come in different gauges? Yes. What type of gauge was used in this case? 12. Is it available in 12? Yes. Now, did you tell Deputy District Attorney Carol Nahara that you can get more than 27 pellets in a size 4 buckshot? Objection, Your Honor, calls for hearsay. Overruled. The witness says, I believe the question she asked me was it possible to encounter a round of number 4 buck that had less than the prescribed 27 pellets? And I said, anything's possible, or words to that effect. So he didn't say that there could be more. He said it could be less, potentially. Mr. Khan says, did you say it happens, but it's rare? I may have used that terminology. And is that your testimony here today that you can get a count other than 27? It happens, but it's rare. Well, I believe I testified to that on direct that I thought it was possible but unlikely. Now, in this case, you didn't make a determination that there were only 6 number 4 buckshots fired at the crime scene, did you? No. And why is it that you cannot make that determination? What I determined based upon the overpowder wads that I found that I could see that at least 6 shots had been fired where overpowder wads were used and 2 rounds were fired where combination wads or wad columns were used. And one of the reasons why you can't determine how many shots were fired in this case is because somebody could have picked up some of the evidence from the crime scene and taken that evidence with them. Is that correct? Objection, Your Honor, calls for speculation. Overruled. The witness says that's possible. And in fact, there were no cartridges found at the crime scene. Is that correct? That's correct. So, it is your understanding that some of the physical evidence was removed from the crime scene before the police even got there. Is that correct? Yes. Now, you said that you found it unlikely that only 6, based upon your knowledge of seeing wounds, you said you found it unlikely that only 6 rounds of buckshot were used. Is that correct? Yes. How many rounds of buckshots would you say was used in this case? I wouldn't put a specific number on it. Why do you rule out 6? Because there's a lot of damage to the 2 victims in this case that I think show that there were more than 6 shots of buckshot fired. Well, what would you say would be the range of shots fired in this case? A numerical estimate. I would say that using a maximum amount of shots that could be fired with an admission from the subject's suspect. Sorry, let me restart that sentence. I don't know why my verbal acuity is going out the window all of a sudden. I'm getting sleepy and been reading for too long for today. So, sorry, apologies. We're probably almost done. I don't know where we're stopping. So, until the next break, I just go until we take a break. So, his answer, let me back up to the question. Well, what would you say would be the range of shots fired in this case, a numerical estimate? I would say that using a maximum amount of shots that could be fired with an admission from the suspects that at least 1 round was reloaded. Again, I'm not asking you to rely upon hearsay. Ms. Abrams says, I'm going to object to him interrupting the witness's answer. Overruled. He may do that to clarify the question. He can cut him off. No problem. This judge has gone rogue. I can't. Mr. Khan says, my question is based upon the physical evidence, your observation of the photographs, your knowledge of shotguns, and the injuries that they cause. You said that you find it difficult to believe that there are only 6 rounds. What would you say would be the more likely number of the range of shots referring to buckshots that were fired here? Buckshot? I'd say at least 10 is a possibility. And it is also your opinion that there were 2 rounds of birdshot fired here? Yes. So that would give us a total of 12. Is that correct? That's a possibility. Yes. Again, he's saying he can't tell you a for sure number. He's saying that's his best guess. Now, when you testified in the first trial, did you use the shotgun that is here in court, to illustrate to the jury how the shotgun is operated? No. What type of weapon did you use in the first trial when you were illustrating to the jury how the shotgun is operated? It was a Mossberg shotgun from our exemplar collection that is functionally identical to the weapon, only cosmetically different. Is it your understanding that this shotgun here in court is not only functionally equivalent to the weapon that was used in this case, but also cosmetically identical? Yes, I believe it is. Which shotgun would you say is closer to the weapon that was used in this case, the shotgun that you used in the first trial or the shotgun that Dr. McCarthy used in this trial? I'm going to object to the question as vague, sustained as to what is meant by closer. Which shotgun would you say is more similar to the shotgun that is actually used in the commission of this crime? The shotgun that you used during the first trial or the shotgun that Dr. McCarthy referred to during this trial? Same objection, overruled. He says, this shotgun. Now, you indicated to the jury that perhaps you can fire 5 shots as quickly as 5 seconds. Is that correct? That might be possible. When you were giving that time estimate, you were not taking into account the accuracy of those shots hitting their targets, were you? Ms. Abramson says, I'm going to object to the form of the question, Your Honor, argumentative. Overruled. Overruled. Just whatever. Anything goes for the state, but when the defense tries to do something, God forbid. The witness says no. I took the question to mean purely how fast could one operate the shotgun and get it to fire 5 times. Have you formed an opinion as to how much time it would take for an inexperienced shooter who had never fired a shotgun before to hit all of the targets that were hit in this case with the accuracy that was found in this case? Accuracy of what? How do you know what they were even aiming for? Like accuracy. Objection, Your Honor. There's been no accuracy found in this case. All right. What was the legal basis for your objection? Misstates the evidence. All right. In the future, if you can confine your objection to the legal basis without arguing it. Objection sustained. You indicate that you were a firearms instructor. Yes. And you have experience dealing with unexperienced shooters, is that correct? Yes. One of the things that you observe in regard to inexperienced shooters is that you have to admonish them not to get into a crossfire situation. Yes. And does that happen at the sheriff's department, that inexperienced deputies get into crossfire situations and shoot and kill each other? No, I don't think we've ever had a crossfire situation where one deputy has shot another deputy. Like, what? What are these questions from you, Mr. Khan? What were you referring to when you were telling the jury about the fact that you've admonished people in the past not to get into crossfire situations? Because it's, especially when dealing with new people, they tend to get a real bad case of tunnel vision and only focus on that when they see right in front of them, maybe not what's behind them. What I'm asking is, have you had situations where you've had deputies firing at each other and striking each other with firearms because of that tunnel vision? I don't believe we have. No. So once again, let me get back to what were the circumstances under which you found it necessary to admonish someone to be mindful of the crossfire situation. Once again, it was when you're telling people one of the things that you teach when you're teaching the use of deadly force is that you have to be cognizant of what is downrange. And we tell to people that sometimes what's downrange may be your partner, because it seems to be something that sticks in their mind a little better. So this admonishment was an admonishment that would apply to a theoretical situation rather than a problem that you observed before you in which two deputies shooting their weapons would actually turn to fire at each other in each other's direction. Is that correct? It's happened with other agents, hence that's why we teach that in our academy. Like, duh. But in your experience as an instructor, you have never seen two deputies get into a crossfire situation where they were firing at each other. Is that correct? No, actually, I've seen that, but not with live ammunition, where we usually see this in role playing when they're out using blank guns and they're still new. And yes, they do, in fact, get in crossfire situations, but they're not shooting live ammunition. I mean, these are perfectly suitable answers to the questions that he's asking. And it's like he's trying to get them on some gotcha, aha, but there isn't any. Like this whole line of cross has been like he's trying to get him on some big gotcha, and there's no big gotcha moment, and it's interesting. It's a tactic. I'm just talking about situations in which deputies are actually using guns with live ammunition. You've never seen that occur. Is that correct? No. Also, Eric and Lyle were not officers training to learn firearm safety. That's why they didn't know. But anyways, um now, did you say that unusual for it is unusual to fire, I'm sorry, it is unusual to find a firearm that, such as the one involved in this case, loaded to full capacity, that is 5 rounds plus one in the chamber? Yes. And why do you say that is unusual? Just in cases that I have handled working in the crime lab, you attempt to determine how many rounds of ammunition that the person started with by, if they did, in fact, fire shots at the scene, by looking at the cartridges cases that are left behind at the scene and what's left over in the magazine or the firearm as it's taken from the suspect. And once again, it's my findings that it's unusual to have them loaded up to full capacity. In other words, the magazine plus the rounds in the chamber. But there's no reason why that can't occur. Is that correct? There's no reason why that can't occur. That's correct. And there's no reason why a person can't just walk into a gun store and say, "Tell me, how do I load this weapon to full capacity?" and how and they could learn right there on the spot how to put 6 rounds in the shotgun. Is that correct? Absolutely. And so you've made no determination as to whether the number of shots fired in this case was 11 rather than 12, based upon the fact that you don't ordinarily find weapons such as this loaded to full capacity, did you? That's not exactly what he said at all. I'm sorry, say that again, sir. Yes, defense counsel said, um, or asked you if you had made a determination as to whether the number of shots fired in this case was 11 rather than 12. Did you make any such determination? Not a hard and fast determination, no. Now you gave it blah, 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 blah. My tongue, my mouth's getting tired. Sorry, guys. You gave an opinion concerning the effects of shotgun blasts upon clothing. Did you examine the clothing in this case? I looked at Mr. Menendez's shirt yesterday. Did you form an opinion concerning how he received? Well, did you see a tear to the shirt? About in the middle of the shirt, almost the middle of both the length and the width, there's two fairly large holes that are right adjacent to one another, and then below that is a smaller hole, and that's all I saw. The shirt is heavily blood soaked, and it's hard to actually see the material of the shirt. And based upon your experience with shotguns and the type of spray patterns that they cause and so forth, did you form any opinion concerning what caused those holes? No. Did you read the testimony of Dr. Lawrence concerning what he concluded caused those holes? No, I didn't. Now, you said that if you were to attempt to reconstruct a shooting, that You would consult with a coroner. Is that correct? Yes. Were you aware of the fact that the prosecution in this case did consult with Dr. Golden? No. Objection, Your Honor. Well, I'm going to object to this, Your Honor, calling for hearsay and irrelevant. Sustained. The answer is stricken. You're aware that the prosecution did receive reports from Dr. Golden. Is that correct? Objection, irrelevant. Sustained. Are you aware of the fact you testified in regard to reports received from Ron Linhart from your office? Is that correct? Yes. And you read and you considered that report? Well, I didn't really consider it because are you asking this in assuming that an attempt that an attempt to reconstruction was made? No, I'm asking you if at any time you read the report of Mr. Linhart. Yes, I did. Was it your understanding, based upon a review of that report, that the prosecution, as well as the investigating agency in this case, did in fact seek the advice and conclusions of Mr. Linhart? Objection, Your Honor, calls for hearsay. Sustained. Speculation. Sustained. You do know the prosecution in this case sought all of your conclusions some time ago. Is that correct? Yes. And you gave those conclusions, is that correct? Yes. Thank you. I have no further questions. Um, I guess they're going into redirect, and we're not going into a break yet, so I will continue reading for a little bit longer here. All right, so I took a stretch break and I got some coffee, so hopefully I can wake up here a little bit. All right, so the redirect examination of Deputy Van Horn. Ms. Abramson says, Deputy Van Horn, is the Sheriff's Crime Lab a branch of the District Attorney's Office in this county? No. Is it your obligation as a sworn peace officer when you are subpoenaed to testify in a case to tell the truth no matter who calls you? That's my job. Is it your job to be biased against criminal defendants and refuse to respond to criminal defense subpoenas? No. In all the years that you've been on the job, have you ever been as rudely attacked by a prosecutor as you were in this courtroom this afternoon? No. I'm surprised that wasn't objected to, but it's fair. It's valid. I felt it. I felt the attack. Is it disloyal for you to respond to a subpoena and testify truthfully to your examination as a firearms examiner in this case? Is it disloyal for you to respond to a subpoena and testify truthfully to your examination? He says, I think it's illegal. She says, illegal for what? To disobey a subpoena. That's not what she asked, but yes, okay, yes, it is illegal to disobey a subpoena. Are you in any way, shape, or form working for the defense in this case? No. And if you were, in fact, giving testimony that was beneficial to the defense in this case, is that any more than your job? Is that any more than your job? Just to testify truthfully? No. Your captain in this courtroom, your captain is in this courtroom, is he not? Yes, he is. And was your captain present for the very first meeting you had with any defense attorneys in this case? Yes. And was it with the specific agreement and cooperation of your captain that we were able to meet with you? Yes. And before we ever met with you, did you meet with the prosecutors or either of them in this case? Yes. Were you invited to that party? You'd have to ask them. What's the question? Before we ever met you, did you meet with the prosecutors or either of them in this case? He says yes. Were you invited to that party? You'd have to ask them. Objection, argumentative, sustained to the form of the question, the answer is stricken. Was any defense lawyer present for your previous conversations with Ms. Nahara or Mr. Khan in this case? So you've had conversations already with the prosecution before you even talked to the defense. Were we there? Did you need to invite us to those meetings? Was that a requirement? Is that something you're supposed to do for your job? Because I'm really not seeing the value of Mr. Khan's questions regarding that whole line of questioning. Was any defense lawyer present for your previous conversations with Ms. Nahara or Mr. Khan? No. To the best of your knowledge, were we ever told that they were meeting with you? I have no way of knowing. To the best of your knowledge, is there any obligation on the part of an attorney for either side to notify the other side that they are having a pre-testimonial meeting with a subpoenaed witness? He says, I'm not an attorney, so I don't know the rules you folks operate under. For all the hundreds of times that you have testified for the prosecution, have you invariably had contact with the prosecuting attorney who was going to call you to the witness stand before you were actually put on the witness stand? Yes. Is it absolutely routine that when you're called as a witness, somebody has some kind of contact with you before you, so that you know why? Yes. And in the overwhelming majority of your experience, has that contact been with the deputy district attorney from the LA County District Attorney's Office? Yes. When you had those pre-testimonial meetings with deputies, district attorneys, were the defense attorneys present? No. When you learned that the prosecution in this case was seeking to call a mechanical engineer to testify to a crime scene reconstruction, did you contact the defense attorney's office and talk to them about your opinion as to whether or not that was a responsible thing to do? Bam. Yes, he says. He contacted the defense when he found out that the prosecution was hiring a mechanical engineer to testify to firearms and uh, mechanical or biomech. They hired a mechanical engineer. Did I say biomechanical? They hired a mechanical engineer to testify to the wounds and all that, Dr. McCarthy. Yet, uh, they should have had a biomechanical engineer for the things that he was testifying to and a firearms examiner. They tried to lump him in as both and even a medical examiner for some of it. All right. So he contacted the defense. I just find that amazing. And did you tell them that Dr. Roger McCarthy's reconstruction was junk science? Objection calls for an improper opinion. Overruled. Yes, I did. And that is that and did you say that it was bogus and should not be used by the district attorney's office? Yes, I did. And that was before the defense had any contact with you. That's correct, isn't it? Now, with respect to your contacts with the district attorney's office, the second meeting that we had, your captain was not present, correct? That's correct. But the assistant director of your laboratory, Mr. Linhart, was. That's correct. And the next morning after that meeting, didn't you, on your own initiative, call Ms. Nahara and tell her everything that we had discussed? Yes, I. Objection, leading. Sustained. The answer is stricken. Did you make a telephone call the morning after our second meeting? Yes. And who did you call? Miss Nahara. Were you required to do so? No. And why did you do so? Because in the past, it's not unusual to receive calls from defense attorneys, and in the past, every time I have been contacted by a defense attorney as a matter of practice, I notify the prosecutor on the case to let them know that the defense is making inquiries. So, did you voluntarily on your own call Ms. Nahara after our last meeting? Yes, I did. And did you convey to her information concerning what questions you had been asked at our meeting and what answers you gave? Yes. Did you freely and fully share with her all of that information? At the time I talked to her, I gave her the best recollection of what had occurred the night before. Yes. Now, would it be fair to say, Deputy Van Horn, that when you're calling or when you're being called as a witness for the prosecution, you don't call up the defense lawyers and tell them about your conversations with the prosecutors? Objection, leading question. Sustained. Have you ever done that? Called up the defense attorneys following meetings with prosecuting attorneys when the prosecutors are calling you as a witness? No. And apart from, by the way, how many times have you had contact with Ms. Nahara and Mr. Khan? I had two face to face meetings. I can't remember when the first one was. It was quite some time ago. And when we had a meeting here at their office, once again, I'm sorry, I don't know the date, and several, well, actually, two or three actual phone conversations and several phone calls that have gone unreturned. Several phone calls that have gone unreturned. So they really didn't care about his testimony now, did they? If they really wanted his testimony, they could have called him. Like, I don't understand what he was just totally being disingenuous in trying to make it seem like it's the witness's burden to let the prosecutors know something about his conversations with the defense when he absolutely doesn't. And for the face to face meetings that you've had with them and these telephone conversations, the defense wasn't any part of those, were they? No. Do you feel, Deputy Van Horn, that you are indeed an expert in firearms examination and ballistics? That's what the courts have found. And did you note in Roger McCarthy's testimony that he admitted he had never qualified as an expert in ballistics? Objection, irrelevant and argumentative. Sustained. Did you read Roger McCarthy's testimony concerning whether he had ever qualified as a ballistics expert? Yes. And do you recall what he said in that regard? Objection, irrelevant, calls for hearsay. Sustained. Why can't he refer back to the expert's own words in his testimony? That's ridiculous. Do you believe having a PhD in mechanical engineering is a substitute for being trained as a firearms examiner? No. When you formulate opinions, Deputy Van Horn, and when you testify, do you try to avoid giving opinions in matters where you don't feel that you are a qualified expert? Yes. Why is that, sir? Because I know my limitations, I know what my field is, and I don't venture from my field, as any good expert witness should know their own limitations and not veer out of their field. So you feel that it is ethical or proper for people to venture from their field when that it is ethical or do you feel, why can I not talk today? Do you feel that it is ethical or proper for people to venture from their field when they are not qualified to do so? No. Now, for many, is it true? We'll strike that. Are there published in the literature concerning shotgun ballistics distance range charts of various kinds? In other words, have there been distance range figures that have been kicked around the ballistics community for years? Well, there's a rule of thumb that's often misunderstood, and that is let's take for instance this pattern that here on D, and once again, let's say that that's 4 inches and you achieve that pattern at 10 yards. Just as a reminder, D would be this one down here. So A, B, C, and D. So that would be the biggest cloud of smoke. The very general rule of thumb is that if you move a yard closer to the group, that the group will be an inch smaller. If you move an inch further away, the group will be an inch bigger. Unfortunately, over the years, people have took that to mean that at 3 feet, the target, or at the muzzle, it's 1 inch and it gets an inch bigger as you go. But that's not, in fact, what happens. That saying or that rule of thumb has been misinterpreted over the years. Okay, let's talk about this then. Are you aware that Dr. Fackler was asked on cross-examination to offer guesstimates of the distances of various wounds, the distance from the muzzle of the gun of various wound patterns in this case. Objection misstates the testimony and calls for speculation and hearsay. Sustained. Samuelson says, did you read Dr. Fackler's testimony? No, I have not read his testimony. He was the witness previous to him, so he probably didn't have time to read through this Dr. Fackler's testimony. You indicated on cross-examination, Mr. Khan asked you a series of questions about the reliability of any estimate. Is a broad range estimate an acceptable thing to give? In other words, if someone says that's distant, that's close, is that acceptable in your opinion? Yes, that would be. And remember, Dr. Fackler was even hesitant to give measurements, but if he was forced to, he gave like a range, if you recall, when asked on the stand. And if you're pressed to say, well, how distant? Is it your practice when you give a, a kind of distances to give a large bracket, a large spread of possible distance? Objection irrelevant as to what the witness would mean. Sustained, it's also vague. Okay. If someone gives an estimate for what appears to be a spread pattern of 10 to 14 feet, give or take 4 in either direction, does that sound like a specific opinion on an actual distance, or is that a range, a possible range? Objection, improper opinion for the witness. Sustained. Well, you indicated to Mr. Khan that you wouldn't agree that it is reliable for someone to say a particular wound pattern could have been produced from 10 to 14 feet. He asked you that a little while ago. Do you recall that? Yes. Would it matter to you as to whether or not it's reliable as to whether the range that was given 10 to 14 feet was given just as a general range rather than as an absolute distance? Objection assumes facts not in evidence and calls for speculation. The court says, do you understand the question? Yes, I do, Your Honor. All right, you may respond. Overruled. The witness says, that's exactly why I just flat refuse to give distance determinations unless I have the shotgun and the ammunition, because just for this reason, that you end up backing yourself into a corner and end up being stuck with distances that could very well be on the money, but because of the wide variances involved, could also be far off. Like I said before, looking at that pattern in D, the only thing I would be comfortable telling someone is that it's not a contact wound. Other people, particularly if you're experienced in the field, might be willing to offer ranges. It's just objection, leading. Saberson says, strike that. This is your personal opinion, correct? Objection, argumentative, sustained. My God. Do you see how difficult it is for her to get an answer out, whereas the prosecutor had wide latitude to just get into whatever he wanted? And if that's not bias, I don't know what is. Ms. Abramson says, have you just told us your own personal limit that you don't want to give any distances? Basically, it's the policy of the firearms section that we don't do that, and that's based upon training that we received from the FBI and their gunpowder and primer residue schools. So basically, the FBI trained him not to give a distance, so he doesn't give a distance. And that's what he teaches, not to give distances or ranges or whatever. So you understood Dr. McCarthy to testify that he started out thinking he could come up ultimately with accurate distance determinations in this case? Yes. And that's something, are you telling us that that's something you would never even try to do? That's correct. Is that because lack of ability or lack of scientific certainty? Well, it would be a lack of scientific certainty where you don't have the firearm and the ammunition involved. Now, with respect to these, the notion that the sheriff's department was unable to effect a reconstruction, is that true? Was the sheriff's department unable to effect a reconstruction in this case? This case was handled by the Beverly Hills Police Department. We provided services to the Beverly Hills Police Department. And basically, we responded to requests from the handling agency, whether it would be an outside agency or our own detectives, and assist them in areas that they ask for help in. We don't stick our noses, per se, into other people's business. So this wasn't their case. He just happened to offer assistance in this case for the Beverly Hills Police Department in the first trial. Second trial, they weren't used, except by the defense. Prosecutors didn't use them. And in fact, the agency that asked you to get involved, at least in this case, was the district attorney's office, correct? In the person of Ms. Pamela Bazanich? Well, I believe that I contacted her or she contacted me by phone at first, but we had a couple of meetings after that with Deputy DA Bazanich and Detective Zoller. And by the way, the defense wasn't present when you were meeting with the previous district attorney in this case either. Isn't that true? That's correct. And you didn't call us to tell us what you said? No. And we never asked you, did we? No. Now, did either the Beverly Hills Police Department, in the personage of Detective Zoller or Ms. Bazanich, ask you to attempt to reconstruct this shooting? No. And have you considered whether or not you would, if asked, have tried to reconstruct the shooting? If asked, I'm sure that we would have tried, yes. And in your opinion, is this shooting reconstructible? No. Is that because the sheriff's department doesn't have the ability or for some other reason? It's for some other reason. And what is the reason why, in your opinion, this shooting is not reconstructible? This is now what the second witness that has said that. So we're now getting that from Dr. Fackler and this completely independent law enforcement officer who wasn't his case. He's really got no skin in the game. He's really just telling it like it is. Happens to switch sides here for the defense, and it just happens to align more with the defense's version of events rather than prosecution, which is just telling, isn't it? Is this because the sheriff's department doesn't have the ability? I read that, sorry. And what is the reason why, in your opinion, this shooting is not reconstructible? Well, to begin with, the number of shots that were fired. We have hard evidence that at least 6 shots were fired, but using the capacity of the gun, and okay, using the capacity of the gun only, not considering the possibility of reloads, you've got a possibility of 12 shots being fired. So we don't have all the evidence. We don't have enough evidence here to do a reconstruction. Would you ever engage in just speculation and call it a reconstruction? No. If you were to go about trying to reconstruct a shooting, would you start out with a preconceived notion of how many shots were fired or what the position of the victims were, and then try to make all the evidence fit that preconceived notion? No. If you were ever doing a reconstruction, would you simply leave out wounds and wound patterns that didn't fit your preconceived notion? No. Even if you had evidence of, let's say you had and knew you had all of the shot shell components that were used here, and so you knew the exact number of rounds, would that be enough to be able to effect a reconstruction of the position of the victims and the position of the shooters and the exact sequence of the shots in this case? So even if you knew all the number of rounds that were shot, could you still reconstruct this case? No. Why is that? That would only be one piece of the puzzle that we were trying to put together. So there was multiple pieces of the puzzle that's just one of many. I think there's too many. Sorry. She says, "Are there too many pieces?" He says, "I think there's too many." Well, at this point, I believe there's missing pieces, and then there's, to me, what seemed like an infinite number of variables. An infinite number of variables of what? Deputy Van Horn. The position of the victims, the position of the shooters, the way they held the shotguns. Now, just briefly, this notion of crossfire, when the sheriff's department is training people, do they train them without live ammunition until they get the hang of it? Well, in role playing, they use blank guns, yes. Is that where you observed that deputies, even after being told about crossfire, still put themselves in crossfire type situations? Yes. Even after being told? Yes. You didn't wait to see if they'd shoot each other before you train them? No. I'm sorry. That was a funny question. Ms. Abramson says, "I have nothing further, Your Honor." And the court says, "We'll take our recess until 5 minutes after the hour." So we will stop here and continue on with more redirect of this witness in the afternoon break. We'll continue. Yeah, there's way too many pages for me to continue going on right now. So we'll stop here and um, we'll finish up tomorrow. Thank you guys so much for watching, for following along with me. I know this is a long trial. I think it like lasted 6 months, but it's important that we look at it and compare it, especially like little things like this. This witness was for the prosecution the first time, and second time around, prosecution doesn't even call them, and then they try to like twist it and make it seem like it's the witness's fault because he's somehow testifying for the defense, even though he could have testified for the prosecution, but they didn't call him. So it's just the bizarre mind games and stuff that they do in this. It's really interesting to see and how different the prosecutors are in this case. That that cross by Mr. Khan was frustrating to listen to because a juror who doesn't know things about the legal system might be like, "Oh yeah, this Mr. Khan has a lot of really good points. Why didn't this guy talk to the prosecutors? Why didn't he call them? Why didn't he, make sure that they were present?" But in reality, he has no obligation to. The defense has no obligation to have the prosecutors present at their pretrial, pre-hearing meetings and things. They don't need. They're prepping for trial. They don't need the prosecutor to approve or, be present at any of their meetings. So it's just very bizarre to me. What do you guys think about it? I don't know. That really irked me reading through that and listening to that because it's almost like I know attorneys are supposed to discredit and impeach witnesses, but do we have to like disparage the witness too? I just don't like that. And to make it seem like they're doing something nefarious when they're not. I hate that. Can we be honest? Can we just be truthful in the courts? Then, maybe things would be a little better. I don't know. Sorry. I had to go on a rant there because I didn't like that cross examination. But I think Miss Abramson's doing a pretty good job rehabilitating that and for people who needed it rehabilitated on the jury, but we'll see. So we will continue next time, finishing off, I believe, his testimony, and then Linhart is next. So yeah, he's going to be on the stand next. So that will be Ron Linhart is also worked with him. It was his supervisor. This witness's supervisor. So we'll get to that in the next one. Thanks guys so much for watching. Please hit the like button, subscribe, do all the YouTube things, and I'll see you guys in the next one. Take care. Bye now.